guilty, Mr. Hall, it's my obligation now to sentence you. You're adjudicated guilty of trafficking methamphetamine and unlawful use of a two-way communication device. On count one, trafficking methamphetamine, you're sentenced to a term of life in prison, given credit for 520 days, time served. On the use of a two-way communication device, you're sentenced to 5 years in the Florida Department of Corrections. That'll run concurrent with count one. You're given credit for 520 days, time served. We have fines and costs of $1,078 in fines and costs. Those include discretionary cost of $2 of local law enforcement education, a $65 assessment additional court cost, $150 discretionary public defender fee payment, and a $200 discretionary fine. The fines and costs are reduced to a civil judgment. There's an additional $50,000 fine based on the trafficking charge. I'm going to assess that at this time, and that will also be reduced to a civil judgment. If you're required to give a DNA sample, you must submit one. You'll forfeit any seized items. I don't believe there's anything else I need to do. All right.
Mr. Hall does have another pending charge that we'll have to address.
Okay.
But if we can maybe have a court date in 2 months.
All right. I'll set that for September the 24th, Madam Clerk, at 9 o'clock. And then, of course, he can be he can be going and transported to the Department of Corrections. Yes, sir.
So what I'm saying, what's up with I just showed you,
Mr. Hall,
this is not trafficking.
I'm going to get to it just a minute. You have a right to file a notice of appeal.
Yeah.
If you wish to appeal your judgment sentence, you have 30 days to file that notice. If you'd like to have an attorney appointed to represent you, one may be appointed to represent you. Would you like me to appoint Ms. McCarthy back to your case where she can perfect your appeal?
Well, I mean,
Listen to me. Do you wish to have Ms. McCarthy appointed back to your case to perfect your appeal? She can file all the paperwork to make sure the Second Circuit Public Defender's Office is appointed to represent you in the appeal.
yeah, I understand that, but the fact that
I've already sentenced you, sir. Do you wish to have Ms. McCarthy appointed back to make sure that your appeal is perfected? If you don't, it'll be up to you.
yeah, I mean, so what if I don't, what?
If you don't appeal,
If I don't have her to,
you can still do it yourself. You'll just be responsible for doing all the notice of appeal and everything else. That's up to you.
Right.
But Ms. McCarthy knows how to do it, and she can do it. She'd probably have it done by the end of next week or end of this week.
yeah. All right. I guess we can do that.
You want me to appoint Ms. McCarthy back to your case to perfect your appeal?
Yes.
All right, Ms. McCarthy, you're appointed to represent him. All right, to perfect that appeal. Sir, you need to step over to make a friend. Mr. Sullivan, you gonna get that designation as the habitual felony offender?
Yes, Your Honor.
All right, let's see. Hold on, Mr. Peters, are you ready for your sentencing? Listen, Mr. Peters, how long is yours gonna take?
John B. Lawrence, Your Honor.
All right.
Brief.
All right.
This is with Mr. Ferreira. Discussions are ongoing. State's made a offer, I think today, of 5 years
Okay.
prison. So I'll go and talk to Mr. Lawrence about that and try to make a counteroffer.
All right, are we ready to set for a trial? We just need to set for another pre-trial.
You took over. I don't know.
Yeah, I
know there
recently
were-
took
there were
over.
depositions of a victim that were done. I don't think any law enforcement was opposed. And then Mr. Peters joined the case.
All right.
I'm not sure where he sort of is, where.
Let me set it for September 24th.
That'd be fine.
9 o'clock, and then Mr. Peters will give him a chance to speak with his client about the plea offer and also if there's any other discovery that needs to be completed by Mr. Peters.
Right. And I'm resolving his misdemeanors today, so they'll be done.
Okay, very good.
Thank you, Judge. That's
Yes,
all.
sir.
I'll see you tomorrow.
All right, let's do the interpreter cases real quick, Ms. Bennett, where I can get Mr. McCarty back. All right, let's see, Ms. McLaren, you ready? Mr. Meredith, you ready? Interpreter?
Mr. Rodani back in
I thought, is Mr. Ricardo back? I'm sorry. Have a seat. I just assumed. I'm sorry. That's what happens when you assume. Ms. Bennett?
Before you is Dexter Owens. This is case number 243340. We're here for sentencing after jury trial.
Okay, and I believe I left the pre-sentence investigation in my office, but I had reviewed that,
Have a copy.
and I just need to file with the corporal. I've reviewed the pre-sentence investigation prior to coming down. I reviewed it when I got it. All right. We're here today for sentencing. Mr. Owens was found guilty of robbery, and discharged the firearm with great bodily harm, aggravated battery, also a special finding with great bodily harm with that. And we're prepared to go forward with sentencing. Is that correct?
That is correct. And Your Honor, we would like you to consider Mr. Owens under the Florida Youthful Offender Act. He was 18 years and 2 months when this incident happened. He has not been previously classified as a youthful offender because he didn't have a history. And he's not convicted of a capital felony or mandatory life felony. And he had no record prior to that. So he checks all the boxes to be sentenced as a youthful offender. And I believe that his mental development would also be well within the youthful offender criteria.
Mr. Sullivan?
I'm objecting to the court sentencing to defend as a youthful offender. While I believe he would technically qualify, I don't believe it's appropriate in this case. I do have some witnesses that would like to address the court prior to the closing sentence.
As do we.
All right, and I'm gonna allow everybody to have a response. I am going to decline to sentence Mr. Owens as a youthful offender based on the nature of the charges and the facts that came out and the facts that were presented at trial. I'll allow the state to present their witnesses first, or statements, and then Mr. Owens give an opportunity, and then
Sure.
let the state, and let Ms. Bennett, I'll let you respond. Yes,
Good
ma'am. Just
morning,
state
Your
your name.
Honor. I'm Karen Horn. I'm Stephen's grandmother. I adopted him 13 years ago on October 12th, 2024. I got the worst call of my life. I told my grandson was shot, and that's all I do. When I got to the hospital, they told me he was paralyzed from T2 down. The bullet severed his spinal cord. My son was almost lost his life that night. They said an eighth of an inch, he would have been dead. Stephen was a roofer. After the Hurricane Michael, he came and literally helped me out because my husband was dying of cancer. He never turned down work. He's been in and out of hospitals from infections to pain to other situations. The doctors have said that he will probably spend a lot of his life in and out of the hospitals throughout the rest of his life. He's been through rehab twice. He has worked hard to even sit up. This changed his life, so he can't work right now. Don't know when he'll be able to work. And now that he's an adult, the insurance has run out. He gets one chair every 5 years, and one was given to him by a friend of mine. His electric chair is broke down, so the expenses he faces are astronomical. Not only did it change Stephen's life, it changed our family dynamic. I am 68 years old and I am his caregiver. His brother and sister help me as much as they can. His dad helps me, but he also works a full-time job. So pretty much it all falls on me. And this is the hardest thing I have ever had to do. It's the hardest thing our whole family has ever had to do. I would like to say that I would like as much mercy for Dexter as he showed my son, which was absolutely zero. I asked for the maximum sentence because a coward shot my son in the back and left him there to die. Thank you for your time, sir.
Thank you, Your Honor, for this I'm Sean Long, I'm Stevens. Now I want to take this time to let you know that this probably is due to the affect my son and me as well in our family. My son was in his last year of school, 1 credit away from graduation. He has worked as a roofer for the past year. Before this incident, Mr. Owens forever altered his life. I personally believe that Mr. Owens had every intention of killing my son that night. The past 2 years has been a complete and utter nightmare, excuse my language. We haven't woke from. My son has been bedridden. 22 and 23. Only by God's grace did he survive the shooting and was not paralyzed, neck down. He has worked hard to get back to some sort of normalcy. He has had multiple complications. He has had multiple complications from this. My son had E. coli 3 times. He had to be quarantined 3 times in a year. He was skeptical. He has suffered. And put into words how this has affected my family, mental health. My son was suicidal for the first year. I'm suicidal. My father, my grandfather was sick. This pretty much put him in his grave. I feel lost. I feel we lost him early because of this. Judge, I am asking you to think about the 1020 life law in this. Please, sir. Mr. Owens has never showed any kind of remorse or empathy. I really don't believe that this young man is even sorry or regrets any part of this, other than the inconvenience of being caught. From the beginning, Mr. Owens has shown that he is a predator, very dangerous, and has made threats to his co-defendant and has dragged his juvenile sister into this chaos. I want to apologize to the family for all of this, and I ask for no leniency for this young man. He showed no leniency to my son, and I just ask that you please sentence him appropriately. Thank you.
We don't have any more.
This is it. This is the same one. Yes, sir.
Your Honor, Mr. Long, the day of the actual trial, wrote up something that he would like. I'm just going to read it as a short paragraph. Mr. Long wrote, I feel like he had multiple opportunities to let me leave and not shoot and let me walk away unharmed. I was not a threat to anyone, and this changed my life so drastically, from my family, my relationships, my health, and my career as a roofer. Everything changed in my life, and not for the better. I've mentally, physically, and emotionally been through hell trying to figure out a new way to live since being paralyzed. Constantly going to doctor's appointments and having infections because he chose not to let me walk away, even though he had multiple opportunities to let me get out of the car. Your Honor, both of these offenses qualify under the 1020 life statute. The jury made the finding of discharge of a firearm causing great bodily harm for both of these counts. So Mr. Owens is looking at a 25 to life minimum mandatory under 1020 life. The court has the opportunity to sentence both of those consecutive, but they don't have to be sentenced consecutively. I've got Mr. Owens at 649 days jail credit. I've kind of gone back and forth on what I was going to request the court sentence Mr. Owens to. Mr. Long is going to suffer lifelong complications. He'll never walk again. And he'll never be able to do most things that most humans take for granted every single day. I believe that Mr. Owens' youth and lack of criminal history are something that the court will consider. And for that reason, I'm not going to ask for life, but I am going to ask for a sentence of 50 years in this particular case.
Ms. Bennett?
Yes, we also have some people that would like to talk on Mr. Owens' behalf.
I'm Brittany Rhodes, Dexter Owens' mom. I'm here today. First of all, I want to say to Mr. Long's family, I'm sorry that happened to your son. I'm not up here looking for sympathy. I'm asking for justice for my son because we all know as young men, we all guilty of something. In anybody's life, you have done something. Only thing that I ask is for my son to get a fair sentence. We all know that sometimes things happen as a mistake. I love my son. That's the only boy I got. I got 2 girls, 3 kids and all. My son always have worked since he was 10 years old. He has battled with mental issues also as a child. So my thing is, regardless of what happened, when people do things in life, do they need to get punished for it? Yes. But do I believe my son meant to hurt him? No. And my thing is, I ask that if anything, that the state, the judge, everybody look at this case closely and make the right decision. And my thing is, the only thing that I got to say is I'm a God-fearing woman. And I installed that in my son. Regardless of what, he looked at everybody as his friend. He have a good heart. He just like me. I give a person a shirt off my back. I'm not gonna sit up here and say my child is perfect because can't nobody say that their child perfect. And if you do, you're a liar. But I do ask that y'all look at this case closely. It doesn't matter about the color, because I got white people in my family. So looking at it as a situation, want to fry my son about something that he didn't mean to do, I just ask that y'all look at it and give him justice. And only thing that I got to say is that we got a daddy that sits high and look low. Regardless of the situation of what y'all do to my son today, it's not gonna dictate how I feel about him because I'm always gonna love him. And what I do want people to know as a parent, don't point fingers until you know what your child really do. Don't call my son a murderer or something that he did when you don't know.
Address it to me, okay?
So I love you, boy.
Thank you, ma'am. Ms. Bennett?
I love you.
That's it there.
Yes, ma'am. State your name.
I'm Jada Hall. That's the Orange little sister. And I just want to ask that y'all, like, please have mercy on my brother. You know, he's a good man, good kid. He never been in any trouble. He didn't mean to hurt nobody. Like, he was just trying to defend me and himself. So I don't want him to get life or anything like that. He's about to be 20 tomorrow. Like, I don't want him to be locked up more than he done spent life outside, you know. Like, I want him to have a proper sentence. Like my mom said, like, everybody should be punished what they do. But you should look at it on both sides. Like, you know, he didn't do what he did for no reason. It's always a reason behind something. He's not gonna go out and just hurt somebody for no reason and not have a reason to do it. Like, what you don't get anything out of just shooting somebody or hurting somebody for no reason. It got to be something that they done did or something that's threatening you or making you feel some type of way. So it's like my mom said, look at it closely. I was 15 at the time when I was in the car when the situation happened. He's trying to protect his little sister. He the man of the house. So just look at it. If put yourself in his shoes, what would you do? So I just ask that y'all show mercy on my brother. You know, like I said, we got nieces, a newborn niece. I want him to get out, be able to help take care of the nieces. I want to have kids. Want my kids to meet him. Like, it's a lot I haven't done with my brother that I want to do. So I just ask that y'all please show mercy. And I'm sorry to the family that this happened, but he's not innocent. So your son is not innocent as well as you want to paint my brother. And I love you, Fliff.
Love y'all.
Mr. Owens?
Oh, yes, sir. I thank everyone for their time today. But I would like to address the court first and say I didn't want to I did not want to go to trial. I felt like I was forced to trial because the state felt, as if they had me dead to the wrong, which I feel like everyone have this situation all twisted and they made it bigger than what it is. Don't get me wrong, I understand that a firearm was used in this situation and what I'm saying, a brother, no matter the skin color, a brother was hurt. And I just felt like that I didn't want to waste anyone's time, but I felt like, this could have been resolved without going to trial, you know what I'm saying? Your Honor, I wrote you something and I sent it to you. Now, I don't know if you read it or not, but I would like to read this to you and add on to it. But Your Honor, I haven't been in trouble before, and I would like for you to take that into consideration. I'm a working man. This whole situation is not being looked at for what it was. I have multiple jobs and would never rob anyone. Believe me when I say that I'm very sorry for what happened to this man. If there would have been another way to get out of this situation without resorting to him being shot, I promise I would have made and I would have taken that option instead. I pray this court believes in my sympathy for him and show me some leniency by not giving me a lot of time so that I can still get out young and better my life. Because I have been and I have had a hard life and been trying my whole life to get it together, working and striving hard for what I want so that my life could be better and make my family proud of me for being successful in life. I pray that this victim forgives me and his family for what happened that night and know that I'm truly sorry and show me some mercy on my life. I pray to God he gets better and have a full recovery so he can enjoy the rest of his life. Your Honor, I pray you take all these things into consideration as you sentence me today. Please show me some mercy and grace. I thank everyone today for their time and hearing me out. I just want to say everyone has a job here to do today. And I know everyone been doing it a while. And I know that, Your Honor, you're very good at what you do. I appreciate your time and consideration in this matter. I don't want to be viewed as a bad person. This was truly a mistake. And I truly wish I would have made another decision. This is honestly was not planned. And I did not want to shoot this man as badly as everyone say I did that night. This was never planned. Your Honor, I have a lot of things to look forward to. Since I have been in here, I've been better in my life, taking courses. I have not been wasting my time. Today, Your Honor, I pray that you take into consideration the young man that I am and the clean record that I have been since a juvenile. I have been disciplining myself with these 2 years of me being inside this jail facility. Your Honor, I first want to address Mr. Long and his family. I'm very sorry for what happened that night. I honestly, you know what I'm saying, pray to God that he has a full recovery and he regained strength in every limb from the top of his head to the bottom.
Division B's in custody pretrial docket. My name is Brantley Clark, Circuit Judge, who's assigned to the Criminal Division B. We have pretrials, trial management. We have a pile of cases, so we're going to move through them efficiently as possible. Who has Mr. Ricardo's cases? Who has the interpreter cases? All right, let's go ahead and bring those out, Deputy Dexter. And who has, is that all? How many do you have, Mr. Ricardo?
I have three, Your Honor. Marlon Alvarado, Carmelo Santiago, and Juan Vargas.
Who else has the other one? All right, is yours out, Mr. Meredith? All right, let's bring them all out. Mr. Ricardo, if you need to go do something else, you can just come back when you get a chance.
Thank you, Your Honor.
Yes, sir. All right, Ms. Bennett, you ready?
Actually, could you pass me so I can talk to Mr. Owens for a minute?
Sure. You don't, okay, Mr. Something, you ready?
Judge, good morning.
Good morning.
Mr. Likes is making his way down. Judge, this is one case that I just spoke to Mr. Overstreet. We'd like to start putting on monthly pretrial if we can.
Yes, sir.
Try to wind things up. We're still completing some discovery on a deposition that I missed
Okay.
because I was ill. And of course, we have some pretrial motions to file as well.
Okay.
So if we could just put this on the August pretrial.
We'll put it on August
having monthly
20th.
court dates.
And if there's any motions,
Call your office.
call the office and we'll probably move to the 21st, but right now we'll put it on the 20th, 9 o'clock, and we'll still keep it on the, I think it's the October if trial, or is it
No, it's at the.
It's October.
end of October,
That's
special trial week?
Y'all quiet down, please.
Yeah, separate, the 10/26 and 11/2. I
Yes, sir.
think I've got two courtrooms reserved, and I think I've done at least everything that I need to do to be ready for that. Okay? So it's August 20th.
Yes, sir. Thank you.
Yes, sir. Have a good day.
Quiet down.
Judge Santini Green is my other one.
Green, come on down.
He's making his way down. Judge, this is one where they had, he's actually, you actually signed an order releasing him on this case back in, let me get my dates right. Looks like September 20th of 24. And then he went to Alabama on murder charges. And I guess they had some issues up there regarding their case, and they're going to have to take it to a grand jury again. And the judge in Alabama put him on, I believe, a bond and ankle
Hold on just a second. Ms.
bracelet.
Bennett, I can't hear right now. Oh, I'm sorry, Mr.
Sorry, Judge. In Alabama, he was released. They're going to take their case back to the grand jury. He made bond in Alabama. They put him on ankle monitor. So he had a hold without bond on a capias that we issued here to keep track of him. So he was brought back on that, but obviously he didn't fail to appear ever for court because he was in custody the entire time. So I think what we need to do is just release him on the Bay County charges and then let Alabama do their ankle monitor, whatever they're doing up there. But we had him released on these charges down in Bay County.
Southern?
Your Honor, I would agree that he didn't fail to appear locally. I wasn't on this case when he was released before. Preferably, my understanding was that he was being released so he could go to Alabama and deal with those. I don't know if that's accurate or not, but that was my understanding. Is we essentially just ordered him so he could go handle the. He's facing murder charges in Alabama, so. I mean,
It was actually, the motion, looking back on it, was discovery issues, I believe, is why we issued the order. We just couldn't get any discovery on this case, but they did have a hold on him the entire time in Alabama as well. He's correct.
but I mean, I will agree that he didn't fail to appear willfully. I mean, I think that's clear.
And the order just, the motion indicated the discovery issue, and the order just said it's a release, so, I'm gonna release him back on that. And then he's got the, subject to that order.
You need to do whatever you're supposed to do on the Alabama, check in or whatever, or
Yeah, he'll be back on pretrial release, so he needs to report into pretrial release, and then, of course, he needs to, between him and Alabama, what he does up there. And then we need to give him another court date.
we do.
Let's set it September, pretrial,
That's fine.
and that's September September 15th, and that'll be at 9 o'clock.
So you have to come back. Judge, that's all I have. Thank you.
Have a good day. Ms. Bennett, are you still talking to your clients? Ms. Bennett, you still talking to your clients?
His family hasn't arrived.
Pardon? Okay. Okay.
Judge, before you is William Green. This is case number 2019 CF 2589. And we ask you to accept misdemeanor plea in absentia
I'll do that.
to one count of no valid driver's license. He will be sentenced on
That's
that.
okay. Just hand it. That's plain abstention. I don't need to hear anything else.
Okay, and then the other two counts, I guess the state will make an announcement that they'll be consolidated.
Sir, you just have a seat. Good luck. And all these pleas and abstention, y'all just hand them to me. I don't want to, we don't have time for the announcement on.
Yes, sir.
I'm not just you, Ms. Bennett. I'm telling
Then the next,
everybody that.
I'll be quick. The next one is Mr. Harold Mangum. Yes, three cases, 243074, 253136, and 253271. I've just recently been appointed to Mr. Mangum. I've received some of the discovery, talked to the state attorney, and there's still a little bit missing. And we'll see where we're at the next court date and hopes to get this resolved fairly quickly.
You want to set this for August or September?
Hey, it's up to you, how long you need to look through everything.
Probably August is fine.
Is that September, August 20th, correct? August 20th at 9 o'clock.
And then I'll let you know when I'm ready for all.
Very good. All right. See, Ms. McLaren, you're still waiting for yours out? All right, Ms. Peskin? All right, Mr. Peters? All right, let's go ahead. Are we ready for Mr. Hall's sentencing, Mr. Parker? Mr. Hall, come on up.
Your Honor, he filed a motion for a Nelson hearing.
Okay. Just, raise your right hand to be.
It says raise your right hand to be sworn for the Nelson.
Raise your right hand to be sworn in. All right, Mr. Hall, state your name.
Alfonso Hall.
You have to speak up. I can't hear you.
Alfonso Hall.
And what are you asking for today?
I want to say something first before we go into the Nelson hearing.
No, sir. I want you to have the Nelson hearing, then I'll give you a chance to speak whatever you want to speak.
I don't have the paperwork right now. I don't have the paperwork right now, but that's what I'm saying.
What do you, if you want a Nelson hearing, you're under oath. Tell me what you want and we'll get forward. We got a sentencing set
Nelson
this
hearing
morning.
is getting rid of me.
Yeah, I know.
Oh, okay. That's what he wants to know.
Okay, well, look. First and foremost, Your Honor.
Speak up. I cannot.
First and foremost, Your Honor, Ms. McCarthy failed to argue the facts and present the evidence that would have proved reasonable doubt in the trial. So that the evidence was planted and submitted by producing body cam footage and in trial showing video and audio. She failed to do this. So the cops forcing me down, telling me to get down, or whatever. So also violating me by digging in my growing area and all that. So I shared this with her, told her she didn't present this in trial. So also the state charged me with well, I had a conviction for trafficking, which it don't meet up the traffic. And I can present that to you today. That's why I was,
Tell me why you want another attorney.
because she didn't,
Anything else?
yes, sir.
Go ahead.
brought to Miss McCarthy attention, even though drugs were planted, I explained to Miss McCarthy that the FDLE didn't show enough for trafficking. She didn't present that either. In court, in trial, I also let her know to present that in evidence. No body cam footage, she didn't present none of that. So like I said, I can show you.
I'm letting you make your statement, then I'm gonna have Ms. McCarthy respond.
All right,
Just let me know when you're finished.
all right. Pretty much that's that. That's about what she didn't present. That's what I'm.
Ms. McCarthy, your response?
Your Honor, I watched the video of the trial yesterday again to make sure, since Mr. Hall had asked for a Nelson hearing. I don't feel that I did anything wrong. The meth that was found on him was enough. Besides the
It was
pill,
allegedly from.
it was 14 grams, and that was testified to by the FDLE person. So there was nothing I could do for that. And as far as them planning it on him, I didn't feel that I could go forward with that.
I'm gonna deny your motion this time, Mr. Hall. I'm prepared to go forward with sentencing.
Yeah, this one.
Your Honor, he would like to represent himself.
All right, Mr. Hall. How far did you get to school? Now, I'm gonna be honest with you, you represent yourself. I'm still moving forward with sentencing this morning. I'm not.
I'm saying before we even go, excuse me, before
No,
we
sir.
even go into that, this is what I'm trying.
No,
to
sir,
explain to
I'm
you.
not continuing sentencing this morning. I'm gonna sentence you this morning, whether you represent yourself or Mr. McCarthy represents you. You understand?
I got you. But
Okay.
what I'm.
Listen to me. If you want to represent yourself, I've got to ask you a few questions.
No,
Okay, so answer my questions. How far did you get in school?
10th grade.
So you read and write.
Yes, sir.
Have you ever represented yourself before?
No, sir.
What do you do for a living?
I do lawn service.
Okay.
Have a couple jobs.
Are you under the influence of any drugs or alcohol
No, sir.
today, which would impact your ability to represent yourself or to make this decision?
No, sir.
Have you ever been diagnosed with a mental illness that would affect your ability to
No,
represent
sir.
yourself? All right. And you understand that Ms. McCarthy is here to represent, she's already represented you at trial. She's here to represent you at the sentencing and to present anything that you'd like for her to present before I sentence you.
Well,
No, I need you to answer that question.
no, sir.
Do you understand that's what she's here for?
So she failed me at that.
Listen to me. Do you understand that's what an attorney's for?
Yes, sir.
All right. Do you wish to still represent yourself?
Yes, sir.
All right. I'll allow you to represent yourself. Mr. Sullivan, you'll go forward. Ms. McCarthy, I'm gonna leave you back up.
All right, so,
I'll let Mr. Sullivan go first.
okay, my bad. I didn't hear you say that. Sorry about that.
Listen, if you represent yourself, you're going to listen to what I say.
Yes, sir.
I'm passing up score sheet and restitution order. Score sheet represents the lowest permissive sentence of 96.125 months. Mr. Hall faces 30 years on the trafficking of methamphetamine. However, I have filed the motion for habitual felony offender designation. I'm going to pass out 3 certified copies of convictions as well as the offender's pen pad. Your Honor, the certified convictions, there's one on top there with sticky note with Mr. Hall's name on it. That is Mr. Hall's most recent certified conviction. That sentence, judgment sentence reflects that he was sentenced on December 13th, 2021. Because we have not gotten to December of 2026 yet, any crimes that have been committed since that date would fall within the 5-year as required by the habitual felony offender statute. The penitentiary pact that I passed up on page, it's the 7th document, the 7th page of the document. There are a couple cover sheets, but at the bottom it says page 2. It shows Mr. Hall's incarceration history with his most recent release from DOC as April 1st, 2024. This particular crime was committed on February 18th, 2025. So less than a year after his release from incarceration.
That's on the page 2.
It says page 2 at the bottom. It's the actual 7th page of the document.
Right. Where's that April?
So it's about midway down. It shows his most recent release. It shows April 1st, 2024 is when he was released. I think there were 3 entries there. And then,
Oh, I see. I've got it right here.
and Your Honor, the The other fact that I'd like to point out is Mr. Hall has been sent to prison for trafficking on 2 previous occasions. This is his 3rd trafficking offense. Because of that, I am asking for the enhanced sentence, and I am asking for the maximum life in this particular case.
Life in prison?
Yes, Your Honor. And Mr. Hall has 520 days jail credit on this case.
Mr. Hall?
Yes, sir. Sir, this is what I want to present to you.
Yes, sir. Go ahead. You got to speak up, Mr. Hawk. I'm having a hard time hearing you.
Okay, Your Honor. Back to what I was saying about this. So, Mr. Sullivan, convicted me on the trafficking, which is not mere trafficking, is 13.862. And you can see it on the FDLE that I got. I marked it out where you can see everything where the 5 baggage that he has in his indictment of the trafficking. It's not trafficking amount. So I'm asking you to, can we do a time served plea on that? Like you said, I have 520 days jail credit.
Okay. All right, anything else?
Yes, also in the FDLE, item number 6, exhibit 12, it says it's not analyzed. So being that that's not analyzed, that takes it down to 11.860.
Here's the pre-sentence investigation I'm gonna file with the clerk at this time. Anything else? You agree with the 520 days?
Yes, sir.
All right, this time I am going to designate, based on the information, the evidence presented to this by the state, I'm going to designate Alfonso Frederick Hall a habitual felony offender.
To evaluate him, but I think she is out of town at the moment.
Okay.
But we finally have.
I need to say something too, Your Honor. I want to say something too.
Make it quick.
Okay, well, since you put it like that, I'm under the impression that, I'm not being taken seriously of in a sense. So I feel like
Let me promise you, I'm taking you seriously, but I'm going to set you for a hearing on August the 21st at 9 o'clock. We'll see you then, Mr. Cotton. That'll conclude the hearing.
Okay, well, I mean.
Yes, sir. Listen, the hearing's over with. We'll talk to you later. Oh, there you go. And I'll take a bunch of these today. Y'all give them.
Can y'all hear us at the jail?
I'm gonna talk to Vaughn. I'm ready to go back. Well, I don't got Vaughn. I don't know why I ain't got Vaughn. You know what I'm saying? And he keep playing this motherfucking game. And she already told me.
Mr. Carter, Mr. Turner, let's go ahead and do Ms. Carter. She here? We're here today on a status review. This is State of Florida versus Sonic Carter, 25 CF 114. Carter is going through restoration process, but she's not doing very well. The last
update that I saw.
Ms. Carter, you're gonna have to start complying with my order. We'll have to either put you back in jail to let you do it or take you to the Florida State Hospital.
Understand? You gotta go to your appointments. He's gonna put you back in jail or back at the hospital, okay?
You understand?
Not just the medicine, you gotta see the counselors too. She's been updating her medicine, but you haven't been seeing the counselor. That's the problem, Judge.
You've got, look at me, Mr.
Look at
Carter.
him.
I'm not kidding. You've got to go through this restoration process. The doctor says you can be restored. You're gonna have to do the counseling. Do you understand?
Yeah.
Okay. I'm gonna set this for September 25th at 9 o'clock, and I expect to have a report that you're cooperating. You understand?
Yes.
Okay, good luck. We have Mr. Hall up. Mr. Carter, you here? Hey, Mr. Hall, tell him to close that door where I can hear.
They say close the door? Okay.
Thank you. Mr. Hall, I brought you back to court today just to place something on the record. I had neglected to do it yesterday. You were sentenced to a term of life, but I failed to place on the record that there's a 3-year minimum mandatory that comes with that sentence. And I'm not sure I have to, but I'm gonna go ahead and announce it on the record today. There's a 3-year minimum mandatory. Okay?
And Your Honor, since he's here, we need to know if if he wants me to represent him on his other case.
Mr. Hall, okay.
Or if he wants to represent himself.
You represent yourself, you want to represent yourself on the manslaughter?
Yes, sir.
Okay. All right, well, I think I've already gone through the talk on that, and we haven't come back in September on that, is that correct?
Yes.
All right, you still have your notice, Ms. McCarthy is going to file your notice of appeal, so that'll conclude
Yes.
today's hearing. Good luck.
Thank you.
Mr. Hatcher? This is Mr. Owens. Case number 24CF 3343. Mr. Owens was sentenced yesterday to a term of imprisonment, 25 years on the robbery with a firearm, 25 years on the aggravated battery with a firearm. They're both 25-year minimum mandatory, and I had failed to place that on the record yesterday. So that's what I'm doing today.
Your Honor, I also want to put on the record that
I'm not putting anything else on the record today. I'm just making, if there's a motion or something, you can file a motion to correct the sentence, but that's not what we're here today. I'm just announcing the 25-year minimum mandatory on both counts to run consecutive. That's all I'm doing today. So if there's any other motions, they have to be filed.
yes, sir, I will.
All right. All right, that'll conclude your hearing, sir.
Hey, Mr. Karen, I want to appeal that. I want to appeal. I just want to let everyone know for the record, I want to appeal this.
I don't blame you. I would too.
Yeah, I mean, that ain't what you gave me, ain't right.
All right, that'll conclude the hearing. All right, Mr. Meredith. Mr. Colvin.
Bitch yeah, man, the bitch ass cracker talking about something just done good. Fuck.
Judge, this is Scott Colvin, case 26-1295. Dr. Schuler, I believe the report was filed yesterday.
Let me read it real quick. I've just reviewed Dr. Schuler's report. Mr. Meredith, Mr. Colvin asking for another assessment.
No, sir.
Mr. Pereira, has the state had an opportunity to review that mental competency examination?
Yes, sir.
Evaluation? Are you satisfied or are you asking for another extra?
We're not.
And any objections to me accepting that report and evidence and finding Mr. Colvin competent to proceed at this time?
No, sir.
That's what I'm prepared to do.
All right. Your Honor, we have 2 PIAs.
All right.
It doesn't need to be fingerprinted for either
You're
one.
going to, you'll get me an order on the competency, correct?
Yes, sir. Miss Copeland's listening in and she'll get that.
What does he have to be fingerprinted on?
He doesn't.
No, he does not.
Oh, that's what I thought. All right, Mr. Colvin, good luck to you, sir.
I mean, Miss Nolan. Your Honor, Ms. Nolan had been evaluated by a doctor and we could not understand what the recommendation was. So Dr. Schuler was appointed to follow up.
Okay.
Dr. Schuler tried to see her the last couple of weeks and Ms. Nolan is expressing an interest in her right to remain silent. So
But then, Ms. Note, if based on that, you're gonna stay in jail
That's fine.
for a long, long time because I can't.
Well, I'm not gonna let you violate my right to remain silent. I'm gonna keep my right to, that test has nothing to do with being competent. It's asking personal questions and questions about my
We'll set
case.
this for September 25th at 9 o'clock. We'll see you then, ma'am.
Yes, sir. And I will come to the jail to talk with you. Okay.
I represent myself and I'm gonna remain silent. That's all.
You're not doing it right now.
I don't care. I trust in God, not man.
Amen, sister. Amen. Me too. All right, Mr. Hatcher, you ready? Okay. Mr. Meredith?
Mr. Martin?
No, not Mr. Robertson, Mr. Martin.
Oh, I'm sorry.
Now, this is Tashad Martin. He's back for sentencing. You accepted his
that's
plea.
right. I don't think we can do this anymore. This is the last one. Sent someone and set them off for sentencing. Complete somebody. Yeah. All right. Mr. Martin, you're before the court today for your sentencing. You've done what you said you did. You come back and you have not picked up any charges. I've already accepted your plea. At this time, you'll be adjudicated guilty of felony battery, sentenced to 24 months in the Department of Corrections, given credit for 5 days served. Your assessed fines and cost of $1,028. Those include discretionary cost of $2 of local law enforcement education, a $65 assessment of additional.
She thought everyone had given up on her. Then Judge Boyd did something no one expected. Most people walk into a courtroom expecting one thing: punishment. But this hearing took a completely different turn. A young woman had been sitting in jail while everyone waited for a placement in a mental health treatment program. Weeks had passed, paperwork had been delayed, and no one seemed able to explain why the process had taken so long. Judge Boyd listened carefully as attorneys and court staff described the delays. Then his expression changed. He wasn't upset with the defendant. He was frustrated with the system. The judge explained that people struggling with serious mental health conditions shouldn't have to wait at the bottom of a list. In his view, they should be treated as a priority because every day without treatment makes recovery even harder. As the hearing continued, the judge learned even more. The defendant's mother explained that her daughter had battled severe mental illness for years. She had been through different facilities, but nothing seemed to address the real psychiatric problems she was facing. Her mother wasn't asking for sympathy. She was simply asking for help. At that moment, Judge Boyd made a decision that surprised everyone. Instead of ending the hearing and telling everyone to wait, he announced that he was personally going to start making phone calls to find a treatment placement. He told the courtroom his goal was simple: to find somewhere safe for her before the week was over. It wasn't just another promise. He intended to make it happen. The defendant's mother couldn't hold back her emotions. Fighting back tears, she looked at the judge and said, "You're an angel." It was one of those rare courtroom moments where everyone could feel the emotion in the room. Judge Boyd responded with humility. "We're going to do what we can do." Several hours later, the case was called again. This time, Judge Boyd had an update. He told the defendant there was finally a plan. She needed to continue taking her medication while the court worked to secure the placement. Then he looked directly at her and said something that perfectly summed up the hearing. "You do your part, I'm going to do my part." It was a simple sentence, but it showed exactly how seriously he was taking her future. Rather than giving up on someone struggling with mental illness, the judge chose accountability, compassion, and action. Not every courtroom story ends with handcuffs. Sometimes justice means making sure someone gets the help they desperately need. And for this family, one judge's determination gave them something they hadn't had in a long time: hope. What do you think? Did Judge Boyd make the right decision by personally